Hello, I'm Carl Seibert, and thanks for joining me. Today, we have some hot celebrity news on our hands. We don't get much of that around here. So let's take a look. What we have before us is a lawsuit, the Splash News and Picture Agency versus Jessica Simpson. Yeah, that Jessica Simpson, the former pop star, clothing mogul, general purpose rich celebrity kind of person. It's a copyright infringement lawsuit, and it also alleges the destruction of copyright management information, which is a form of metadata, and that's why we're here talking about it. So let's scroll down in the lawsuit, get past the preliminary nonsense, and here we are. This lawsuit alleges that a Splash News photographer in early August of last year photographed Jessica Simpson leaving a hotel in New York City. So in other words, these are pictures of a celebrity walking across a sidewalk. That is apparently of interest to a lot of people because the Daily Mail licensed these photos and published no less than a dozen of them on its website. The lawsuit alleges that Simpson or someone acting on her behalf, almost immediately upon publication of these photos in the Daily Mail, copied one of them and posted it to Simpson's social media accounts, to her official Twitter and Instagram accounts, which have millions of followers. It further alleges that the photo had, on the face of it, down near the bottom, a watermark, basically, that was a copyright notice stating that Splash News owned the copyright of this photo, and that Simpson or her agent removed that copyright management information, presumably just by cropping it out of the picture, before they published it online. The suit goes on to make the actual copyright infringement claims, and there are two of them. And then claim 3 for the removal of copyright management information in violation of 17 U.S.C. Section 1202. That's the Digital Millennium Copyright Act, Section 1202 of it. And here, these people reiterate what they said before, that Simpson took the photo and removed the CMI and that sort of thing. And then we have defendant's removal of the CMI from the photograph was intentional, and defendant's distribution of the photograph was with knowledge that the CMI had been removed without authorization. And remember, these are allegations. These haven't been proven. But if the facts that they allege at the top of the lawsuit turn out to be true, well, yeah, cropping something off the face of a photograph pretty well establishes that you're acting with intention and you know what you're doing. And this further subjects defendants to liability for statutory damages under 17 U.S.C. Section 1203 in the amount of up to $25,000. Now, Section 1203 defines statutory damages for the destruction of copyright management information as to be between $2,500 and $25,000 per instance. That's a significant sum of money. That should catch our attention pretty well if we are copyrightable content creators of copyrightable content. Because we know, probably from sad experience, or at least from the sad experience of a friend or business associate, that if you have to file a copyright infringement case, if you are unable to qualify for punitive damages, there might not be much money on the table at all. You might only get a reuse fee, and a reuse fee doesn't pay a lawyer. And what that means is that you're helpless. You can't pursue justice or compensation for the infringement of your work because it's just not economically practical. This kind of money is economically practical. This will pay a lawyer. This means you can get the recovery, maybe, that you're due. So that's pretty big news. So let's take a closer look at this CMI thing. In this particular case, here's a sliver of one of the Splash News pictures from the Daily Mail website, and we don't know which Splash News picture is the one being referenced in the lawsuit, because for fairly obvious reasons, it's no longer posted on Simpson's social media accounts or on that reality TV website that's also being sued. No big surprise there. So there's over a dozen of these pictures, but they all serve to illustrate the point. Here, the lower corner of the picture, we find a copyright notice. And that's what's alleged to have been stripped away when the photos were republished. Now, let's take a look over here at Section 1202 of the Digital Millennium Copyright Act and see what we're talking about, and we can see if that applies to us or what we might need to do to make sure that we can benefit from this. Okay. The first thing it says is that you can't falsify copyright management information. Okay, that's not what's happening here. However, removal or alteration of copyright management information is exactly what's being alleged here. No person shall, without the authority of the copyright owner or the law, intentionally remove or alter any copyright management information, and then distribute, which basically means to post or publish or whatever, copies of works, knowing that copyright management information has been removed or altered without the permission of the copyright owner, and knowing or having reasonable grounds to know that this will induce, enable, facilitate, or conceal an infringement. So they're talking about destroying CMI knowingly and intentionally. And those are two pretty high hurdles if you're bringing a case, but it's not undoable, particularly if your case is one like Splash News's, which is based on copyright management information that's on the face of a photograph for absolutely everyone to see. Then we have a definition of what copyright management information is. It means any of the following information conveyed in connection with copies of a work, including in digital form. That's the definition of metadata, friends. That's exactly the definition of metadata. And including in a digital form includes just about everything in today's world. That's anything on the internet, anything on a computer, anything on a phone, anything on a DVD or a CD. Practically any conveyance of a work in today's world is digital. And this says including in digital form, which implies that the only other thing that exists, which is analog works or conveyances of them, are also included. And yeah, there have been court judgments that confirm that yes, the copyright notice on a physical work does count. And then it goes on to describe things that count as CMI. And remember, it's any of the following information. You don't have to do all of these things. And it talks about information about the work, identifying the work, the title, whatnot. A notice of copyright, information identifying the author of the work or information about the author of the work, information identifying or about the copyright owner of the work, and it once again says, including the copyright notice. It says some things we don't care about. Then it says the terms and conditions for use of a work, or identifying numbers or symbols referring to such information or links to such information. Now, if these folks had sat down with the IPTC standard and written this law to follow the IPTC standard, they couldn't have gotten much closer than what they've said right here. They're talking about the information that's contained in our caption field, our title object name field, the headline field, the author's name field, all of the contact information for the author, all of the contact information for the copyright owner. Usually it's the same person in the case of a visual work, but it kind of doesn't matter. There are fields for both in the IPTC fields and the extended plus fields. The copyright notice field, terms and conditions, why that's the rights usage terms field by definition. And identifying numbers and symbols and links can appear in any of those places, and particularly in the plus extended information. Now, I don't actually know of a recovery based on CMI destruction that was specifically embedded IPTC metadata. But as I said, they couldn't have made this definition match embedded metadata much more closely if they had tried. I have to believe the only reason we haven't seen a lot of actions based on embedded metadata is the business of proving intent, which can be a little bit tricky when we're talking about something that you can't see on the surface of a work. You do have to look. Although in many publishing circumstances, particularly if you use WordPress, the most popular CMS on the web, or most of the professional publishing CMSs, like the one that we presume that the Daily Mail might have used, you're going to see metadata whether you look or not. It's going to be surfaced and it's going to be presented to you right on the page when you work with a picture. So this is all really good news for photographers and creators. Make sure you do the metadata the way you should do the metadata for your own benefit, the benefit of future generations and all those other people for whom we do metadata, and you're covered. If you ever get caught in a situation where you're infringed and you have to sue, you have that information working for you. Now, what about if you're like our friends at the Daily Mail here? And by the way, I will include a link to this page if you want to see the photos of Simpson. I'm not going to show them to you. I could under fair use doctrine, but I'll be darned if somebody's going to steal them from me and re-victimize Splash News on my account. When I looked at the pictures on this website, most of them had all their metadata stripped off. Now, historically, I understand why news websites decided to do that back in the early part of the century. But that was then. This is now. The situation has changed dramatically. Nowadays, we don't own all the pictures that we publish on websites, news websites or otherwise. We're being entrusted with those copyrighted works by their owners. And the neighborly thing for us to do is to protect their rights as best we can. Protect that CMI in case somebody steals a work off our site that belongs to our business partner, somebody that we should be looking out for. That's just the right thing to do, regardless of the law. And if your website is stripping CMI off of images, you should look into that and change it. It's just the thing that you should do. It's the right thing to do. What about legally? Well, if we pop back over here and look at the conditions that have to apply for somebody to be guilty of stripping CMI, it seems to come down to this having reasonable grounds to know business. That could go either way. Does that mean you could be liable for just stripping CMI off somebody's work, whether or not an infringement really took place? I don't know. But the point is, it doesn't matter. You should be preserving the CMI anyway, just because it's the right thing to do. Never mind that if somebody interprets a sentence here in this law in a way unfavorable to you, it could cost you your entire business. It could be everything. $25,000 a picture, and let's say you published a couple of dozen of them, that's it. That's the ball game. And the other side of the bet is however much time and effort it takes to make sure that your site is not stripping CMI. And that could be almost nothing. It could be a few minutes. You could check with your hosting provider and find out that you're golden right now. Or your hosting provider could make the necessary changes for you in a couple of minutes. It might be more work than that. It might be an afternoon. It might be all day. But considering that the other side of the bet is everything, and considering it's something that you should be doing anyway, there's not much to discuss here. We need to go out and make sure that our websites are properly preserving content creators' copyright management information. It's just that simple. Once we've done that, this worry is off the table. We just don't have to worry about it. We're doing the right thing, and we can move on to do the things that we need to do to make our businesses work. Once again, I'm Carl Seibert. I do thank you for joining me and taking the time to watch. Reach out in the comments. Let us know if you've ever been involved in an infringement suit. Let us know if you know of a copyright management information suit that hinged on embedded metadata. And for real, until next time, mind your metadata.